Hello, everybody, and thank you for joining us today to this event regarding the MiCA and the new implementation regarding the EU legal framework and the UK-based approach. I want to introduce the managing partner of New Balkans Law Office, Mr. Kamen Sholev, who will be our moderator.
Hello, good morning. For me, I am currently in a time zone where it is early in the morning, but my colleagues are all in the East European time zone, and so there will be a mixture of brains. I welcome everyone to today's webinar. This is a topic which has been now of interest to both investors, private individuals and parties, governments and others for perhaps coming close to a decade more seriously. And of course, various crypto assets and digital assets have been with us for a very interest in from the deals with the regulation of such assets. While many of our clients have been considering issues relating to the MiCA regulation, and in that context, been considering their understanding of digital assets, that issue is, in our view, still of live interest, and will be perhaps becoming of more live interest in the coming months. And therefore, we thought we will put on today's webinar. This is a very short event. We do hope to organize further such events in the very near future, and we will communicate to you about them. We will have 4 speakers today, and we will start with my colleague, Rezestina, who will talk to us in an introductory manner, comparing the approaches taken to crypto assets in the UK and the EU. Rezestina is a young lawyer, and in a relatively young sector, she has taken a keen interest in this, but she has already delivered several talks on the subject, and we are therefore very much looking forward to hearing what she has to say. This will be followed by my colleague Nevena, who is a partner at New Balkans Law Office. Nevena, based on her experience of Bulgarian lawmaking, will be introducing to you the steps taken in Bulgaria to give effect, if not implement, the new European legislation. Nevena will be followed by Maya, who will talk to us about something that is dear to everyone's heart, and that, of course, are various aspects of anti-money laundering compliance and related issues in the context of crypto assets. And then we'll round off with myself giving you a brief introduction, a few example situations and scenarios in relation to disputes in the crypto space. Hopefully we will of course be on time, and hopefully in addition to that we will even have a few moments for answering questions, and you are welcome to send those to us afterwards as well. With that being said, I hand over to Ina, who will start us off. Thank you very much.
Hello, everyone. I will start with a brief summary and introduction about MiCA, and then we will make a short comparison between the UK and the EU approach to crypto assets. So let me start with that. MiCA establishes the European framework governing the issuance, public offering, and provision of services related to crypto assets. Broadly said, it divides crypto assets into three groups, but we will discuss this further in our next slides. And let me say that MiCA entered into force in 2023 and became fully applicable in December 2024. So, where do we stand with crypto? Let me introduce the comparison between the EU and the UK. So, taking into account the ever evolving crypto sector, we are at a point where the legal framework tries to catch up with technical and economical developments related to crypto assets. MiCA, as you may be already aware, covers crypto assets which have not been previously covered by European legislation, financial legislation. And MiCA comes as an attempt to regulate for the benefit of users most of the currently known tokens, but it also creates a broad category with a lower degree of requirements for legal compliance. MiCA also has a complex approach because it creates its own framework for certain kinds of assets, and it also refers to already existing rules, which can be analogically applied, as we will see. The UK model is a little bit different. While MiCA tries to create a rather uniform approach to crypto assets, despite its references to other acts, the UK model at its current state provides for diffuse regulation only to some kinds of crypto assets and only to some operations with them. The current regulation in the UK is contained in different acts, and the UK's aim is to create a framework covering all of the crypto assets by 2026, where the current rules will be kept, but with an additional layer of rules directed at assets and activities which are not regulated by now. Both approaches are partly triggered by the need to protect users as their number has risen in the last years and to create stricter rules for the business. Let me now explain our table about the types of crypto assets which MiCA regulates and introduce a brief summary about crypto asset service providers, which will be further discussed by my colleague Maya Ivanova in the next slides. So let me start with the asset reference tokens, which maintain a stable value by referencing another value or right or a combination thereof, including one or more official currencies. Electronic money tokens, on the other hand, maintain a stable value by referencing the value of only one official currency. And yes, this is a difference with the asset reference tokens. Also, there are other tokens, which is the broadest category, and other tokens are all tokens which do not fall within the first two groups. And of course, we have the crypto asset service providers, which do not issue or offer crypto assets, but provide crypto related services. So, do an issuer or a firm need a license? What are the requirements about the white paper and how is type of the crypto assets regulated? The answers to all these questions depend on the type of the crypto asset, because when it comes to asset reference tokens, only credit institutions or authorized legal entities can be issuers or offerers of such tokens. And whether a license is needed depends on the type of the legal entity, because if it is a credit institution, it means that it is already licensed and it can continue carrying out its activity without the need of further license. Where there is a legal entity which aims to provide actually to offer or issue as reference tokens in future. This means that this entity shall apply for a license under MiCA. And how are as reference tokens regulated? Only under MiCA. When it comes to electronic money tokens, they are equal to electronic money, and that's the reason they're regulated not only by MiCA but under Directive 2009/110. And only credit or electronic money institutions can issue or offer electronic money tokens. So under MiCA, they do not need a license, but they need a license under the respective directive or regulation applicable to them. So any new entity which aims to provide electronic money tokens shall apply for a license for a credit or electronic money institution. And it shall prepare a white paper, but only to notify to the general public and to the competent authority. While the issuers of asset reference tokens are always obliged to have their white papers approved by the competent authority. And when it comes to other tokens, any legal entity may be issuer or offerer. It doesn't need a license, and its white paper shall be only notified. Other tokens are regulated only under MiCA. Crypto asset service providers are companies which provide crypto-related services, and they need a license under MiCA only if they try and they aim to provide crypto asset services in future. For example, if the CASP is already licensed, for example, as a credit institution or an investment firm, it doesn't need a new license. CASPs typically do not produce a white paper. It can be done, but only as an exclusion, in exclusions. And CASPs are regulated under MiCA and under other EU legislative acts, because, as I said, a CASP can be a credit institution also, and it will be subject to different regulation. Let me now continue with the next part of our presentation, the UK perspective, because I think, yes, we are here. UK approach is a little bit different, but the difference is not such big, because the competent authority in the UK, the Financial Conduct Authority, divides crypto assets into two groups: security tokens and electronic money tokens. Security tokens are regulated and akin to specified investments, such as shares and debt instruments, while electronic money tokens mean the definition of electronic money. And also, all other tokens are unregulated and currently fall outside the regulatory scope. Practically, this means that cryptocurrencies are not regulated, and that buying and selling cryptocurrencies do not require an authorization by the Financial Conduct Authority in the UK. But there are rules for the promotion of such activities. Okay. Let me now continue with the acts which regulate crypto-related activities in the UK. There are different acts. For example, the money laundering regulations, which refer to the FCA registration obligation. Even electronic money tokens and security tokens are not fully regulated. The AML rules apply to crypto businesses within the UK, and any company providing crypto exchange services or custody of wallets shall register with the Financial Conduct Authority. I mentioned only crypto exchange services and custody of wallets, and that's not a mistake, because only these services are regulated for now. This practically means that not all activities connected to crypto are subject to authorization by the Financial Conduct Authority. Other applicable acts are also FISMA 2023 and FISMA 2000 Amendment Order. FISMA 2023 lays the foundation for the regulation of fiat-backed stablecoins, and the amendment order sets out rules for the promotion of buying and selling crypto assets, but only for promotion. The next step is the roadmap published by the Financial Conduct Authority. In 2025, a series of consultations is planned, and also the regulatory regime is expected to come into force in 2026. What is interesting is the approach of the UK, because at first the plan was divided into two phases. Phase one, which was related to the creation of rules for stablecoins, and phase two, which was related to the creation of rules for other crypto assets. Right now, the most recent information allows us to understand that now the government aims to adopt both phase one and phase two at the same time. Let me now move to the pending Digital Assets Bill. The pending Digital Assets Bill does not introduce anything new into the UK. It comes to confirm already existing case law. And the question here is whether crypto can be regarded as property in the UK. There is case law, as you can see. We here quote the lawyer versus persons unknown and others. And this is a case where Mr. DeLoya claimed to be a victim of a cryptocurrency scam. He was induced to transfer cryptocurrency, and once the cryptocurrency had been received, it was transferred between several accounts multiple times and then passed through a digital wallet owned by one of the defendants. After this passed, the cryptocurrency was taken as fiat currency. After this pass and after it has been transferred to another defendant. Part of the claims of Mr. DeLoya were for unjust enrichment and triggered the following question related to crypto. Can crypto assets be followed and or traced? The answer to this question depends on whether crypto assets can be regarded as property. The High Court concluded that cryptocurrency can attract property rights and can be followed, but this was not done in Mr. DeLoya's case. The High Court confirmed that crypto is neither a thing in action nor a thing in possession, which are the two main categories of personal property in the UK. But crypto is rather a separate form of personal property. Mr. DeLoya's claims were dismissed as he failed to prove that his funds reached the digital wallet of the respective defendant, and not because there is a lack of opportunity to trace or to follow crypto assets. The High Court's judgment was related to cryptocurrency only. And the pending Digital Assets Bill will have a broader scope because it aims to cover all crypto assets and not only cryptocurrency. So in conclusion, despite the difference in stages of development of the crypto framework in the European Union and the UK, both are trying to create regulation with broad scope, which will bring stricter requirements for the business to comply with and better opportunities for the users and clients to safeguard their rights. Now, let my colleague, Mr. Kamen Soilev, continue with the introduction of my next colleague.
Yes, thank you very much, Ina. There is actually a couple of questions from those who have joined us, and I wonder whether either you or anyone else can address them. They have come up to this point, so that's a convenient point to ask them, I believe. My apologies, the questions are coming up. So one of the questions is whether EU-based CASPs can provide services to clients outside the EU under MiCA, and whether there are additional considerations they should be aware of. Anyone, please feel free to take this one.
Hello again from me. Let me introduce myself. I'm Maria Ivanova. To answer the question that was already asked in the chat, MiCA does not offer a separate regime for third country companies, meaning that non-EU CASPs cannot provide services in the EU without full authorization. An exception exists under the reserve solicitation provision. If an EU client initiates contact with a non-EU CASP on their own exclusive initiative, the CASP may provide services without MiCA authorization. However, this exemption is narrowly interpreted. Any form of solicitation, including advertising or marketing efforts directed at EU clients, disqualifies the CASPs from this exemption.
That's clear. Thank you, Maya. I suppose one follow-up I would have on this one is it's clear that any form of advertising or marketing activity cannot constitute, cannot be shoehorned into reverse solicitation. That reverse solicitation requires an active effort on the part of a customer. But is there any guidance as to how, in your mind, or in anyone else's, if they're happy to answer that, how does a CASP document reverse solicitation, and what steps should be taken to demonstrate that it was indeed reverse solicitation? Or is it sufficient to simply document that there is no attempts at marketing, so the negative fact of the absence of marketing is enough?
Well, I think you know as well as anyone else that a negative fact is very hard to prove. So in my opinion, it would be good as the AMLR, which I'm going to talk about a bit later today, and the MiCA require for the record keeping to be very detailed and to be kept for 5 years after the end of the business relationship. That way, by saving emails and communications with clients, which is what regulation mandates, that's how this can be proven, that there was no solicitation on behalf of the CAS, but rather from the client.
Thank you. There is a further question, and I wonder whether we can deal with this question just as efficiently as the first one in the interests of time, which is from Marco. And the question is, can EU-based authorized CASPs provide services within the EU, in other EU member states, under passporting rules?
Yeah, I think I can
Thanks.
Try to answer this question as well. Just give me just a moment, please.
Sure.
Yes, EU authorized CASPs can offer services to clients outside the EU under the MiCA regulation. While MiCA does not impose restrictions on providing services globally, CASPs must ensure they comply with the regulatory requirements of the jurisdiction they operate in. This includes adhering to local laws, anti-money laundering standards, and consumer protection rules. Additionally, CASPs must maintain robust operational and security practices in line with MiCA's requirements, even when serving clients outside the EU. I think my colleague Ina can add to this answer, so I'll give the word to her.
Ina, is there anything you would like to?
I was going to answer Marco's question. I think we missed.
Yeah, this was Marco's question.
Can EU-based authorized CASP provide services to other EU members under passporting. The general answer to the question whether EU-based CASPs can provide services to other European countries is yes, but this is subject to prior notification to the competent authority of the state of license of the CASP.
Wonderful. So just as a reminder to everyone who has joined us today, feel free to ask questions like Marco very kindly did through the chat function in Microsoft Teams, if that's how you have joined us. And with that being said, I now turn over to Nevena. She's going to talk to us about how, about a very parochial perspective of Bulgaria. We're obviously conducting today's webinar in English, and we have a partly international audience. We have, however, a substantial part of our webinar's audience today is Bulgarian, it appears, and therefore this will be particularly interesting to that part of the audience. But in any event, Bulgaria will be an interesting example for implementation. And in addition, of course, it takes up a increasingly significant share of the European blockchain industry, both in terms of the development of Web3 tools and applications and businesses, but also in terms of the servicing of such businesses, or indeed in the accumulation of crypto assets takes place in Bulgaria. There was, and that's a final factoid, there was an interesting question as to whether Bulgaria is one of the top, as a state, is one of the top holding nations, in particular of the cryptocurrency Bitcoin, and the answer to that question is still unknown, but there's a strong indication that that might be the case. With that being said, over to Nevena.
Thank you, Carmen. Hi, everyone, and thank you so much for joining our webinar today. I'll be talking about MiCA and what Bulgaria's law means for the future of crypto in our country. After the adoption of the regulation, Bulgaria has initiated important legislative changes aimed at harmonizing its national legal framework with the new EU rules. The proposed Crypto Asset Markets Act, which was approved by the Council of Ministers at the end of 2024 and is currently under parliamentary consideration, is intended to serve as the primary legislative instrument for implementing MiCA at the national level. The main objective of the law is directly aligned with the goals of the regulation, namely to establish a secure and transparent environment for the crypto assets in Bulgaria. A key focus of the regulation at this stage is to ensure a high level of consumer protection within the crypto asset market. As mentioned, one of the main mechanisms for achieving this is the introduction of a standardized white paper for each crypto asset. This is especially important for retail investors who are often exposed to misleading advertising. By requiring transparent and comprehensive disclosures, the legislation seeks to reduce misinformation and enable investors to make better informed decisions. In terms of regulatory supervision, the draft law designates the Financial Supervision Commission as the competent authority responsible for the oversight of crypto asset service providers, as well as for issuers of asset reference tokens and other crypto assets. The Bulgarian National Bank, on the other hand, is responsible for supervising the issuance of electronic money tokens, consistent with its broad mandate concerning payment systems and monetary policy. When it comes to asset reference tokens, the draft law assigns the Commission a wide range of duties, including issuing, refusing, or revoking licenses for the public offering and trading of asset reference tokens. An important procedural rule is that if the Commission does not respond within 6 months after receiving a complete application, this will be treated as a tacit or also so-called silent refusal. However, this procedure does not apply when the issuer is a credit institution. As mentioned, credit institutions can publicly offer asset reference tokens and apply for trading approval, but only after their white paper has been approved by the Commission. They need to notify the Commission, essentially, of the token, and this should be included within their scope. Crypto asset service providers, in addition to asset reference tokens, issuers, the Commission also decides on the licensing of crypto asset service providers. Certain already licensed financial entities such as credit institutions, central securities depositories, investment intermediaries, electronic money institutions, asset management companies, and alternative investment fund managers do not need to obtain a separate license to provide crypto asset services. Instead, they must notify the Commission and receive a confirmation that their operations comply with the applicable requirements. The draft law provides for a similar procedural element as with the asset reference tokens. If the Commission does not decide on an application within 6 months, this will be treated as a tacit refusal. Besides the mandatory paperwork needed for licensing under the regulation, the draft law also sets out additional documentations and checks to assess and confirm that a CASPs government is properly in place. These requirements apply to the management team, shareholders, and ultimate beneficial owners. The draft law also introduces transitional provisions for entities already operating in Bulgaria as virtual asset service providers. These entities will be allowed to continue their operations until the 31st of December 2025. By that date, they will need to fully comply with the new regulatory standards introduced by the draft bill. Alongside implementing the regulation, the draft law amends several existing laws to create a comprehensive regulatory framework for crypto assets. Another important point to mention is that the company registry and the registry agency will record a company's right to operate as a crypto asset service provider in the company registry, but only once the license is issued. This step ensures that information about authorized operators is easily accessible to the public. In terms of consumer protection, the law provides that crypto asset holders, users of crypto asset services, and other interested parties, including consumer associations, can submit complaints to the Commission. Complaints can be submitted if they believe that offerers, applicants for trading admission, issuers of asset reference tokens, or crypto asset service providers have violated the regulation, the law, or implementing acts. All complaints must be submitted in Bulgarian and in writing. To ensure compliance with the new legal framework, the Financial Supervision Commission or its deputy chairperson will be granted broad powers. Among them will be the ability to suspend or instruct a crypto asset service provider to suspend the provision of crypto asset services for up to 30 consecutive business days. The Commission can also publish or require the service provider to publish information that could impact the delivery of crypto asset services with the aim of protecting retail investors and ensuring the proper functioning of the market. Further, the Commission can publicly announce when a service provider fails to meet its obligation under the regulation. It can ban the trading of crypto assets or ban the trading of asset reference tokens on a crypto asset trading platform if a breach is found or there are reasonable grounds to suspect a breach. If necessary, the Commission can also order a crypto asset service provider to stop offering their services if the provider situation could harm the interests of clients, especially non-professional holders. Further, the Commission has the authority to suspend or ban marketing communications if there are reasonable doubts about a violation of the regulation. Moreover, it can revoke or restrict a license of a crypto asset service provider if a breach is established. When it comes to credit institutions acting as issuers of asset reference tokens or crypto asset service providers, if a violation is found, the Commission may apply the same enforcement measures that I have just described, or propose action to the Bulgarian National Bank under the Law on Credit Institutions. The Bulgarian National Bank must notify the Commission of its decision within 1 month after receiving the proposal. When it comes to penalties, the draft law sets out fines under the applicable rules, and fines are pretty high. They may range from 700 euros to 350,000 euros, and in cases of repeat violations, they may reach up to 700,000 euros. For legal entities, the penalties are higher. They can be fined up to 2.5 million or between 1.5 and 12.5% of their annual turnover, depending on the violation and whether it is a repeated offense. In cases of serious breaches, the penalties escalate significantly. Violations under certain articles may result in fines of up to 7.5 million or 7.5% of the company's annual turnover, and in cases of repeated offences up to 15 million euro or up to 15% of the annual turnover. As noted, the draft law is expected to proceed through the parliamentary phase. However, no significant deviations from the current text is anticipated. Thank you all so much for joining us today, and we hope you find the webinar valuable.
Thank you, Nevena. Thank you very much. There are some questions which have come through, which are on the general issues relating to CASPs, which I think it's appropriate to ask at this point. If, however, Nevena, you wish to comment in any sense from the perspective of Bulgaria, then please do. The question which we have concerns the following. It's how are essentially CASPs defined? What are the range of activities which are included within the definition of a CASP? And specifically, if you're not a wallet custodian and you don't execute any transactions in crypto or any trades, do you need a MiCA license? And I believe that that's a question that Ina might wish to go for.
Okay. Sorry. Okay. Some of the services which CASPs provide include operating a trading platform, transfer services, and those portfolio management. Of course, there are many others, but generally, if you do not provide custody, execute trades, transfers, or other regulated crypto services, and operate purely outside these, for example, if you provide software only, you likely do not need a MiCA license.
Okay.
That's the general answer to this question, I think.
Thank you. In the interests of time, unless anyone has anything else to add on that question, I'll quickly ask only one more. This, I believe, is one for Nevena, and it's a question from Angela. Do you have any idea, says Angela, when the law would be ratified? And is the deadline of the 31st of December going to be extended? 31st of December 2025, of course.
We don't have a clear deadline, but I think we should have a law by the end of the year. This is of course, my assumption, but we don't have a specific deadline. When there is a draft bill, it's all up to the Parliament, and it needs to go through the various sessions of the procedure to become a part of the legislation.
Thank you. Moving on, in that case, to my colleague Maya, who will wish to talk to us about compliance obligations for CASPs.
Thank you, Kamen. Today, I will provide a concise, practical overview of the legal obligations that CASPs must now meet under these regulations. We will look at how MiCA introduces a harmonized licensing regime, imposes new governance and capital requirements, and outlines transparency rules that affect how services are offered to clients. We will also cover the AMLR's impact on crypto space, including how it brings CASPs into the core of the EU's anti-money laundering framework, which mandates customer due diligence and transaction monitoring and enforces the travel rule to improve traceability of crypto asset transfers. As my colleague Ina already mentioned, one of the key goals of MiCA is to streamline how CASPs are licensed across the EU. The great thing is, once that authorization is granted in one member state, it works across the whole EU. So it's a true passporting regime. No need to reapply in each country. Authorized CASPs have to meet strict governance and organizational standards. For instance, Article 67 sets out minimum capital requirements depending on the services offered. These range from €50,000 to €150,000, as laid out in Annex 4 of the regulation. To give you a more concrete example, if a CASP is offering high-impact services like crypto custody, fiat to crypto, or crypto to crypto exchanges, or running a trading platform, they will need at least €150,000 in capital to get started. Article 72 goes even further, requiring CASPs to have solid internal controls and strong processes in place to manage any potential conflict of interests. And when it comes to dealing with clients, Article 70 and 71 make it clear. All communications must be fair, clear, and not misleading. That means being upfront about fees, the nature of the crypto asset being offered, and any associated risk. All of these rules work together to make the crypto space more secure, transparent, and trustworthy, protecting investors and making the market more resilient. The Anti-Money Laundering regulation was officially adopted on the 31st of May 2024, as I'm sure many of you already know. This regulation marks a turning point. For the first time, the EU, has established a single, directly applicable AML rulebook. In other words, there's no more room for different interpretations by individual member state. This helps eliminate the patchwork approach we had under the previous AML directives and brings consistency across the EU. A critical point to highlight here is Article 3, Section 1.d, which formally brings crypto asset service providers under the AML umbrella. CASPs are now treated just like traditional financial institutions when it comes to anti-money laundering and counter-terrorist financing obligations. So what does that mean for CASPs in practice? First and foremost, CASPs must carry out customer due diligence. This includes verifying client identities using reliable and independent documents. For legal entities, it's essential to identify and verify the beneficial owner, the individual ultimately controlling the entity. And in situations where the risk is higher, such as dealing with politically exposed persons or clients from high-risk third countries, enhanced due diligence is required. CASPs must continuously monitor transactions and customer relationships with systems in place to detect suspicious or unusual patterns in real time. This means having the right tools and technologies to flag anomalies as they happen. For example, if a customer who usually transfers €500 per month suddenly sends €50,000 to a high-risk jurisdiction, the system should immediately flag this as unusual and trigger an alert for further review. All records related to customer due diligence, transactions, and suspicious activity reports must be kept securely for 5 years after the end of the business relationship or the completion of a one-off transaction. This helps ensure traceability and support investigation if needed down the line. Any transaction suspected to be linked to money laundering or terrorist financing must be reported without delay to the relevant financial intelligence unit. Tipping off is strictly prohibited under Article 35, ensuring that clients are not alerted to ongoing investigations or reporting activities. AMLR aims to unify these practices across the EU, thereby closing regulatory gaps and reducing risk of arbitrage between jurisdictions. Another key operational requirement under the new AMLR framework is the implementation of the travel rule, set out in the Article 31 of the regulation. This is further reinforced by the amended transfer of fund regulation. Whenever a crypto asset transfer exceeds €1,000, CASPs are required to ensure that specific information about both the sender and the beneficiary travels with the transaction. This includes full name, account identifier, address or national ID number, and the purpose of the transaction, if it's applicable in the specific case. Excuse me. The aim here is clear: to enhance the traceability of crypto asset transfers, especially in the context of cross-border transactions, and to support law enforcement and financial intelligence unit in detecting and investigating potential money laundering or terrorist financing. This brings the EU fully in line with FATF Recommendation 16, which sets global standards for the travel rule in both traditional finance and the crypto space. For CASPs, this means taking proactive steps to upgrade their transaction processing systems. CASPs need to have technical solutions in place to securely collect, transmit, and protect this data, while also ensuring compliance with data protection regulations and operational efficiency. In short, the travel rule is about building transparency into crypto transactions, making sure the right information is always available when it counts most, without compromising security or privacy. A common question concerns the white paper requirement under MiCA. This obligation, detailed in Article 5 to 15, applies specifically to issuers of crypto assets, not to CASPs in their service capacity, unless they are also acting as issuers, of course. While CASPs are not required to publish white paper themselves, Article 6, Section 1 obliges them to ensure that a white paper is available and valid before they offer or list a token that is subject to this requirement. Non-compliance can result in administrative liability, particularly if a CASP facilitates the distribution of crypto assets lacking proper disclosure. Both the MiCA and the AMLR introduce substantial sanctions for non-compliance. This highlights the importance of robust compliance frameworks for crypto asset service providers, as the penalties are significant and can have a severe impact on operations. Under MiCA, Article 111 to 115 specify penalties for non-compliance with its provisions, which can be substantial. Legal entities can face administrative fines of up to 15 million euro or 10% of total annual turnover, and individuals may incur fines of up to 700,000 euro. Violations under MiCA may include operating without the required authorizations from the relevant authorities, failing to provide key disclosures or failing to disclose critical information as required under the regulation, inadequate governance and operational control, which might endanger the market integrity or investor protection. Under the AMLR, Article 41 sets out the penalties for breaches related to anti-money laundering measures with significant consequences for non-compliance. Institutions can be fined of up to 10 million euro or 10% of their annual turnover, and individuals can face fines of up to 5 million euro. Non-compliance violations under the AMLR may include failure to perform due diligence on customers or transactions, inadequate monitoring of transactions and record keeping, or failure to report suspicious activities as required under the regulation, or breaches of the travel rule, which we already mentioned above. Beyond financial penalties, of course, both regulations allow for severe enforcement measures, including suspension and withdrawal of authorization to operate as a CASP, asset freezing, which prevents further transactions or access to funds, which can severely impact liquidity and business continuity, managerial bans, preventing individuals found in breach of the regulations from holding management positions or performing critical roles within the organization. Public disclosure of violations, which can cause significant reputational damage and erode trust in a service provider. These penalties and enforcement measures are a clear reminder that compliance is not just about avoiding fines. It's about maintaining the integrity of the crypto asset industry. Embedding a culture of compliance and having the right systems in place to monitor, report, and act on suspicious activities is essential to prevent these significant risks. For CASPs, this means putting compliance at the heart of their operations. To conclude, the enforcement of MiCA and the AMLR represents a significant shift in the governance of the crypto assets ecosystem in Europe. Compliance is no longer optional, it's fundamental to the operational integrity, legal standing, and long-term success of the crypto asset service providers. Thank you for your attention. Now I'm pleased to hand over to my colleague Kamen again, who will present and discuss the topic of crypto disputes.
Thank you, Maya. Just to highlight that we do have some questions, which we will try to ask a question from Vlad in the Q&A, and no current questions in the chat. I'd be grateful if you could direct your questions either to the chat, preferably, or to the Q&A, if you have any. Having said that, the question from Vlad, probably, in fact, there are two questions from Vlad. probably can be dealt with after I quickly tell you what I was hoping to tell you about. I am a partner at Balkans Law Office, which is, of course, a Bulgarian law firm, but I happen to be also English qualified, and my practice in England is primarily as a barrister, which then means that I tend to be involved in disputes. So this is a topic that is quite favorite to me, and therefore apologies for talking to you about something that that is a bit of a hobby. The crypto disputes are, of course, something that has come up quite extensively in the English courts. What I will hope to tell you about is just to give you an overall view of how such disputes come about, what kind of questions are asked, and also a little bit of an idea as to what are the means by which one can make use of various legal systems and obtain their assistance. I will only be hinting at that. I will not be talking about questions today of jurisdiction or of applicable law, which are, of course, relevant to this point, but I would rather be telling you about a tool which is available in English law, but is not available in Bulgarian law, for example, in relation to crypto assets. With that being said, allow me first to give you an overview of the kinds of contexts in which crypto assets can come to the attention of judges. So one category, and that is closely, the first two categories are closely related to each other, is where you have a dispute over title to crypto assets. The question in those cases is who owns the given crypto asset of whatever nature it may be, whether it's a cryptocurrency, whether it is an NFT, or any other type of digital asset. The question is one that then relates to the question of whether property is capable of existing. And Ina earlier indicated that the answer to that question in England has been that yes, it is. There was, of course, an analysis conducted by a working group of eminent scholars and practitioners and a judiciary some time ago, and Sir Geoffrey Foss reported on this, and then that has been the basis of a number of decisions, both at the interim and at the final stage in English courts. So in England, there has been little doubt that property can subsist in digital assets, that they do not come within pre-existing categories of property in England. They are a new subspecies of property, a sui generis subspecies, but nevertheless, they are recognizably property. That then means that disputes about such property rights can arise and can be resolved by the courts. And that becomes particularly relevant in the context of fraud. And here there are a number of mechanisms through which one can assert title, or one can recover the value that those assets constituted. Interesting questions have arisen about, for example, what might be the duties of software developers who have been working on developing a protocol that then is used to organize a digital asset and to distribute it. In the case of Bitcoin, there was a very well-known, a very famous dispute in the last several years in English courts, which dealt with the claims of a Dr. Craig Wright in relation to being Mr. Satoshi Nakamoto, the pseudonymous, likely pseudonymous, or most probably pseudonymous inventor of Bitcoin. Dr. Craigwright could not ultimately prove that he is Satoshi Nakamoto. But in one of the cases which a company related to him had brought, Tulip Trading had brought, that concerned the situation in which keys, not only have Bitcoin been lost, but also keys relating to Bitcoin wallets had been lost. And the only solution, it was asserted on behalf of Tulip Trading, was to for the software developers to create a situation or engineer a situation where the property effectively could be recovered. So in that scenario, the English courts agreed that in principle, software developers might stand in a relationship of being fiduciaries to those who hold the digital assets that are issued. It was a sufficiently definable group, was one of the arguments, and therefore in that group had to envisage the possibility that through their actions they could effectively allocate property rights, and therefore they had to, in principle, be assigned some degree of responsibility. Was that very tentative answer which the English courts gave? It was tentative because it didn't have to be anything more than that. That was the stage of the proceedings, and that interim nature of many of the cases is something that I will return to briefly. On this slide, you would also see that there have been a number of cases connected with IP, in particular in the EU courts, not in the English ones so much in relation to trademarks. I'll briefly mention that later as well, and also in connection with, I don't know if any of you particularly remember that craze, but in connection with NFTs. I say craze, of course, in the best possible sense of that word, not in any pejorative sense. If we can move on to the next slide. I'm not going to deal extensively with the prospects of disputes relating to the regulation of financial services, but it stands to reason that now that MiCA is law, now that there have been a number of other regulatory developments that have clarified also in England and in other jurisdictions this point, there may well be not quite a US-style wave of disputes relating to the regulation of financial service provision, but there will certainly be an EU-style, it seems to me, spate of case law that will come to the courts of the European Union and the member states relating to MiCA and relating to its implementation. Perhaps touching on some of the questions that have been asked earlier today relating to passportization, perhaps, or to reverse solicitation and generally to promotional activities, but also relating to the various duties that CASPs will have. One is of course yet to see those cases, but it's a space I think should be watched. I also want to highlight that in the context of insolvencies, that's again related to proprietary disputes relating to cryptocurrency. One can ask questions, and those, for example, include the point about segregation and duties that a holder of such assets on behalf of another might have to segregate them whenever there is a relationship between the customer and the service provider. That question of segregated accounts and of safekeeping will arise. And the questions also surrounding valuation and what is the appropriate method, what is the appropriate time of valuing those assets, because of course they have a highly fluctuating value, or at least historically they've had. And also to highlight that disputes about essentially title over or existence of crypto assets can arise also in the context even of family law. I'm not even covering half of the possible scenarios where such disputes can arise. So you can imagine, for example, the data protection aspects of digital assets are also potentially an area of dispute. If we can move on to the next slide, please. So having indicated to you what kinds of questions can arise, I now also give you a few thoughts of what has to date arisen in English courts. And Ina already mentioned that there's been case law on the definition of crypto assets. The next bullet here deals with whether the fact that crypto assets are on chain helps in clarifying title over crypto assets, for example, in the context of following and of tracing. Briefly, these are concepts of the English law of English law of property, both the common law and the equitable law of England have these concepts, and indeed there is the principles involved here are concerned with the identification of property, where following is essentially following the same piece of property as it makes its way through different hands, whereas tracing is a situation where property no longer quite looks the same, is perhaps mixed into a mixed fund. So are these questions of evidence that typically arise, how are they resolved? That's something that has been dealt with in the Deloya case and several others, both on an interim and on a final basis. There are also interesting questions arising over, and I indicated in the case of the Tulip trading case that was relevant over the control of private keys. And I've highlighted the question of valuation. A further point that has been of interest to me in particular in the context both of advisory work and otherwise is as to the liability of the participants in a DAO, a decentralized autonomous organization. And of course, DAOs are used in order to typically launch tokens, and they are a new species, but the law has to try and process what they are in its own terms. Again, in England, there has been a Law Commission paper on this subject. There is as yet limited case law, but this is a space to watch to what extent are various members of a DAO liable, for example, if the DAO is analysed as a partnership or as an unincorporated association. DAOs typically leave the matter hazy and are not specific in the context anyway of the so far occurring disputes. They have been, but the question is whether that is likely to continue in future. And if we can move on to the next slide, please. Just this slide is just by way of saying the EU really has not seen much cases so far. There has been one decision that I was able to identify of some substance, and that's the Skatteverket case, the Swedish Tax Office versus David Hedquist, and that dates back to 2014 and dealt with the question of whether crypto assets are a commodity or are a currency, and it came down in favor of them being currency for very sound practical reasons in the context of VAT, which this concerned. If they had been a commodity, then then questions of VAT would have arisen for all suppliers of that commodity on all transactions. And the types of reasons which had led the EU to exclude financial assets from the scope of VAT when they changed hands kicked in here for the Court of Justice of the European Union very sensibly. So they were not found to be such. And if we can move on to the next slide, please. So I wanted to briefly, and my apologies, we're running slightly later, briefly give you an example of one case in England. I mentioned that England can, where you can go through the jurisdictional gateways and establish the jurisdiction of English courts, can be a very useful jurisdiction in which to conduct disputes relating to crypto. One reason for that is that there have been many such cases, that the English common law is very flexible and tends to accommodate rapidly new technological developments. And of course, over the last few years prior to the introduction of MiCA, the European Union has not seen much law giving in this regard, and therefore, understandably, the European courts have been less active. I should clarify, of course, national European courts have seen cases, but not as much, I believe, in my survey as the English ones. The other reason why the English courts are a good forum in which to conduct such disputes is that they tend to also have a number of tools, such as, for example, the notion that you can bring proceedings against persons unknown. And this was the case of Bunyaem versus Persons Unknown, which came to the English High Court in 2023. This case concerned a Thai national, an estate agent, I believe, in Thailand, who had been duped, it seemed, into purchasing some tether and then transferring it to an account, subsequent to which, in a manner that perhaps is not rare or unfamiliar, one of the defendants in this action had their staff had asked her to pay various fees in order to have the funds transferred, but she had ultimately lost substantial value. There were 3 groups of respondents and defendants in this action, and 2 of those groups fell into that category of persons unknown. By comparison, in Bulgaria, of course, one cannot bring legal proceedings against persons unknown. In England, however, that is possible, at least as long as those persons are, in principle, identifiable, and at the interim stage, at least as long as they can be once served, they can be quickly and immediately realize whether they're part of that class of persons that is being addressed, for example, by an injunction. And so in this case, however, the question was whether you could have final judgment against those persons. And the judge, who was sitting in the High Court in London, decided that 2 of the groups of defendants could be given a judgment against. That was the Class B and the identified company INGFX Limited. So Ms. Bunyaem could recover against Class B and against the 3rd group, but she couldn't recover against the 1st group. What was the difference between the 1st and the 2nd group? It was that that 1st group was not capable of being named in principle in the judgment of that particular judge at the time when the issue came up for summary judgment, as it did. And the fact that they were not capable, whereas the holders of certain specified wallets were in some sense capable in the judgment of that judge meant that that first group couldn't be the subject of that judgment, but the second group could. Now, I have some questions as to the distinction made between the first and second group in terms of their being capable or not capable of being identified. But, and you're welcome to look up the case for yourselves and see whether you agree with the judge or not. But I think the broader point is more important. Those who held those wallets, at least, as well as the specific identifiable defendant, were capable of receiving a judgment against them. And if we could move on to the next slide. This is, of course, to say that you should feel free to contact us if you have any questions in relation to crypto in its regulatory context, in the context of its implementation in Bulgaria, or in relation to disputes of a cross-border nature, perhaps touching on Bulgaria. And we have the contact details that you see on screen. However, before we conclude, and thank you all for your participation and patience, I should say that we have a couple of unanswered questions from Vlad, and I will ask at least one of them quickly. When is the Bulgarian law implementing MiCA expected to be approved? I think that question may have been answered in the meantime, wasn't it? That was asked of Nevena, and we can't give a specific answer. Nevena, if I'm not mistaken, that's what you said, but rather, yes.
Yeah, that's it.
But we expect that it's very likely to happen before the end of this year. The Bulgarian political process is such as everyone knows that it moves in sort of a fitful manner. Sometimes things move shockingly quickly, and sometimes they stay in a stable position for quite some time. But there are, of course, obligations here Bulgaria has in relation to starting to apply. They're not the obligations of implementing a directive, as this is a regulation, but in order to avoid criticism, Bulgaria no doubt will move on this. And the other question is based on the on certain guidelines, the EDPB guidelines of 2025. It's a comment, I believe. It seems that the EU wants to delete public blockchains if they store personal data. Among other provisions that endanger the crypto sector, says Vlad. Are we aware of this, and do we have a comment? Vlad, in the interests of time, I think we will deal with this question. We should have your contact details, or you should feel free to contact us. Final point made by Stanislav is that as the law has not yet been adopted in view of the 6-month period for deciding applications, do we consider Bulgaria is a good option to apply for the license, or would we rather suggest other EU jurisdictions? I think that's a very valid question. Any takers for our final question?
I would say yes. I mean, Bulgaria, to my knowledge, there are still a lot of EU countries that are yet to introduce the regime. So Bulgaria is one option that is definitely worth pursuing. Specifically, when it comes to government fees, obviously that will be something that would be worth considering. So yeah, we recommend Bulgaria.
So the process of essentially, we're saying that the process of achieving registration and authorization in Bulgaria is reasonably predictable generally. The Financial Supervision Commission is technically competent and conducts its proceedings in reasonably good time, usually within the time that strictly within the time that is provided for, and in addition to that, the cost of obtaining a Bulgarian license is lower than that in other EU countries, and therefore it may in fact be a good option. Well, thank you everyone for participating today, and we look forward to being in contact with you in the future and to having more opportunities to discuss issues around digital assets with you all, and look forward to staying in contact. Please note, if you don't already have them, our website address, where we occasionally